Maybe, we'll never know, because Roberts' decision was so tied to the particular facts that it's hard to generalize from the decision, hard to say what the holding of Snyder versus Phelps is, without reciting all of the facts that the court mentions as being relevant or important in some way. Yeah?
So given that the government action that the First Amendment is protected against, is the court saying that the court applying damages to this case, right? That's what the First Amendment issue is. The court is saying the court can't apply damages to speech.
Right, can't penalize a speaker by imposing damages on the speech.
Doesn't that sort of nullify both intrusion and intentional emotional distress as torts? Because isn't that always about the courts applying damages?
No, no, it doesn't, because in most situations, neither of these involves public speech at all. Intentional infliction of emotional distress can be a boss berating an employee and calling them names and stuff like that. That can be intentional infliction of emotional distress. And intrusion doesn't necessarily involve speech at all. It involves going someplace, intruding physically into a space, and maybe nothing is ever said or published. So the torts survive this case. They definitely do. Yeah.
I think when you look at it, from the First Amendment, it is clear that it's protected. I think the biggest, that's why I want that. But I think it's the biggest limitation, like you feel for the person.
You sure do.
But I mean, truly, yeah,
Well, that's what Robert says when he concludes his opinion. Speech is powerful, can stir people to action, move them to tears of both joy and sorrow, and, as it did here, inflict great pain. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we've chosen a different course to protect even hurtful speech on public issues, to ensure that we do not stifle public debate. That choice requires that we shield Westboro from tort liability for its picketing in this case. That's highfalutin First Amendment stuff that he's putting out there, and trying, I think, to soften the blow to the public when they read about this decision that the court says that these wacky protesters with their hateful messages have to be suffered. We have to allow them. They can say, oh, what's the Supreme Court done to us now? Well, Roberts is trying to soften that blow by explaining the value judgment that our country has made in the First Amendment. Some people are going to get hurt by freedom of speech. That's the price we've got to pay for that freedom. Yes. Isn't what? Yeah, does he lose his right to complain about an intrusion into his privacy by putting an obituary in the paper for his son's funeral? That would be a harsh outcome, wouldn't it? You lose, assuming you have rights to complain about what the protesters did, but by placing an obituary in the paper, you lose your right to complain against the misdeeds of these wackos? I don't think so. It would have to be more than that. I mean, he's out there in front making speeches to the public. He's not going to be able to complain about an intrusion into his privacy. Well, as part of the reaction to the Supreme Court's decision, the California legislature got together and promptly passed a bill. This called for bipartisan action. It's really rare in legislative affairs these days that the two parties get together. The bill passed, this is Senate Bill 888, passed 75-0 in the Assembly and 37-1 in the Senate, that required funeral protesters to stay 1,000 feet away from funerals and forbade protests based on race, religion, sexual orientation of either the deceased or the persons attending the funeral. And Governor Jerry Brown vetoed the bill and said that he was very tempted to sign it. This kind of conduct is offensive to nearly everyone, but this conduct is protected by the First Amendment. That the 1,000 feet zone was too big, a buffer. Nobody could see or hear the protests. It was not, in Brown's view, a reasonable time, place, and manner restriction. And more importantly, and this is clearly correct as a First Amendment matter, the law, as it was passed by the legislature, targeted the content of the protest. And the court has spoken on that. That is, the protests would be forbidden only if they were based on race, religion, sexual orientation, so on. And Snyder versus Phelps, the decision of the Supreme Court, prohibited that. Okay, anything more that we need to clear up about Snyder? Take a 30-second break while I find Dannie Martin. Well, Dannie Martin was one of my clients, and a colorful character, a great writer, a great First Amendment speaker, but he was shut down by the government. Dannie was a crook, and he was an alcoholic and a heroin addict, been in jail a lot, picked up on crimes of all kinds, knew a lot about jails. He was caught in a bank robbery in a little town up in Washington State, convicted of bank robbery and sentenced to 33 years in federal prison, where he had plenty of time to educate himself, to read, and then he started writing. And he had a remarkable gift as a writer in writing about what he knew, which was jails and prisons. Back in '86, he was in the federal prison down in Lompoc, down by Santa Barbara, and he sent off to the San Francisco Chronicle an article that he had written about what was then just coming to public attention, the AIDS epidemic in prison. And it showed vividly how serious that was and how worrisome it was to both prisoners and guards. The article was sent unsolicited to the San Francisco Chronicle, and it landed on the desk of the editor of they used to have a Sunday section of the paper called the Sunday Punch. And it had opinion pieces and feature articles and so on. And Sussman liked what Dannie wrote, decided to publish it, and just as a matter of routine, sent off a check for $100 to Dannie as the standard freelancer's fee that the Chronicle paid. And the article ran, and Dannie then continued to submit more articles for the Chronicle and became the most popular contributor to the Sunday Punch over the years. Everybody was reading him. He published a lot of articles for the Chronicle. And he won national awards, Fritz Howard National Journalism Award, Society of Professional Journalists, National First Amendment Award, Board of Supervisors passed a resolution commending his contribution to understanding the unique and eloquent portraits of prison life, and so on. And the federal prison officials, they knew what this was going on. They knew that they could censor the mail, and did, and they knew what Dannie was doing, and that he was being paid for it, and they didn't do anything about it until in June of 1988, he published a piece called The Gulag Mentality, which was critical of the new Warden Risen at Lompoc, who had come into the prison and instituted some new policies. He closed the recreation yard in the morning completely. He confiscated, one of the things that the prisoners did was personalize little chairs that they could use out of the open areas, and he confiscated their chairs. And then he had guards sit in on the therapy sessions the prisoners had with counselors, with the prison's only psychiatrist. And the Gulag article quoted some prisoners as being worried about a potential riot in view of some of these new policies that the warden had instituted. And Dannie knew that this was risky to talk about potential riot, but he also knew that the first demand of rioting prisoners is, let us talk to the press. Let our grievances be heard by the public. And so Dannie decided that they shouldn't have to wait until after the riot to have the prisoners' grievances aired. And the warden's policies seemed kind of petty and would naturally make the prisoners unhappy. Prisoners have so few privileges that taking one away is always an issue with them. The article, though, made Risen, the warden, unhappy, and he sent the guards around to round up Dannie and lock him up in administrative detention, which is usually called solitary confinement, but it's not really solitary confinement. The bars on the cell are open, you can see people and so on, you can talk to the people in the adjoining cells, you can pass them notes if the guard doesn't catch you doing that. And he was charged, having been locked up in administrative detention, with violating several Bureau of Prisons rules, published regulations of the Bureau of Prisons, that prohibited any prisoner from conducting a business while in prison. Some securities fraud prisoners, the Bernie Madoffs of the world, would love to continue conducting their business from prison if they could, while the Federal Bureau of Prisons prohibited conducting a business. They also prohibited receiving compensation for correspondence with the news media, as well as acting as a reporter, as well as publishing under a byline. Those were 4 different rules that Dannie Martin was charged with in the prison disciplinary system. Let's pause for a second and look at these rules. Are they content-based? No. Correspondence with the news media, conducting a business, acting as a reporter, publishing under a byline. They do not appear to be content-based, do they? Not targeting the content of what Martin is writing in any way. Rather, they're status-based, based on the fact that prisoners are prisoners with diminished First Amendment rights. And why is that? Why do prisoners have diminished First Amendment rights? What is the government interest that justifies restricting the First Amendment rights of prisoners? Anybody there?
Prisoners give up that First Amendment right because they chose to do something in the act of crime.
They chose to give up their First Amendment when they committed the crime. Committing the crime ousts the First Amendment rights of whoever it is.
Certain rights.
Certain First Amendment.
Certain First Amendment rights.
Somebody got a hand up, actually. How do you characterize the government interest that notion relates to? Mark?
If you use that logic, the government used to be like, well, we don't want to be reporters, but let the individual gain much more power than the other prisoners. And one prisoner has so much power, they can say riot or whatever they do.
Yeah. What difference does it make that one gains power over other prisoners? Why does the prison care about that?
Guards are outnumbered and they do very, very, very violent.
Yeah, it's fair. The interest, the governmental interest, is the interest in maintaining prison security. And that's what prisons are about, right? To keep these folks on the reservation and make sure they don't escape or destroy the place or commit crimes inside. They have an obligation to maintain prison security. So that's the interest that's at the root of any restrictions on the constitutional rights generally of prisoners and First Amendment rights in particular. So. Yeah, well, the way the law has grown up, the mere fact that one commits a crime, the mere fact, what lawyers like to say, that one commits a crime does not forfeit all constitutional rights or all First Amendment rights. Incarceration in a place that has to maintain security means that restrictions that are required to serve that interest in prison security are valid and constitutional. And in this case, in the Dannie Martin case, you've got rules that are not content-based, so strict scrutiny is not required, nor is the time, place, and manner restriction thing the requirement of narrow tailoring. Rather, it's just what is logically connected to the interest in prison security is permissible. That is, the officials can impose restrictions that are logically connected to maintaining prison security. And in the Dannie Martin context and in others, the prison officials have adopted what they call the big wheel theory, which is that they want to keep prisoners from developing their own power base by becoming media heroes and attracting a following both within the prison and outside, which the prison officials say makes it more difficult for us to keep the lid on. We can't risk having these big shots, these big wheels, running the place. Yeah, sorry, takes a while.
Well, doesn't this shed some negative light on the prison for enforcing the law now, because of Danny's choice of submitting an article on the warning? Doesn't it shed like a negative image of having prison now enforcing the rules?
Oh, I see. That it's okay as long as he writes these little innocuous stories that don't really upset anybody. But when he uses one that is critical of the prison officials, when he writes one of those, that lowers the boom on him. That triggers the governmental action. Yeah, you would think that would play into this. But the rules themselves, under attack, or at least that were imposed on Danny, are not content-based and apply to him. The fact that they let him go before doesn't mean that they can't put a stop to this now. He's conducting a business, he's acting as a reporter, he's publishing with a byline, cut it out. We're going to discipline you, put you in the hole, and not let you do that anymore. Well, that's what they decided to do. And they locked him up, and Danny brought a First Amendment lawsuit in federal court in San Francisco. The trial judge, Judge Legg, sort of a middle-of-the-road Republican judge, issued an order temporarily stopping the officials from enforcing those rules against Danny while the lawsuit was pending. Then it went to trial, and Danny was brought up from the prison. He actually had been transferred to Arizona. When he was locked up, he was allowed to call Peter Sussman, his editor at the Cron, and said, "They locked me up." And Sussman tried to intervene. He talked to the warden and so on, and the warden said, "I'll look into it." And what they did was they shipped Danny to a prison in Arizona, out of the environment that he knew and what he was writing about. So he was in Arizona at the time the case went to trial. He was brought up to San Francisco, where they continued to publish. He wrote another 20 articles for the Chronicle while the case was in court. And the warden Risen came in and testified. Expert witnesses in prison security and so on testified about the need for these rules that the Bureau of Prisons had imposed. And after hearing all the testimony, Judge Legg handed down a terrible decision in 1990, ruling against Danny and the Chronicle. The Chronicle sued too, on every point, and he dismissed the case. He did grant Danny the right to appeal, finding that the appeal, quote, presents substantial questions. And I agreed to represent Danny on the appeal, in which the Ninth Circuit argued that the Constitution doesn't stop at the prison gates, and that prisoners retain at least some First Amendment rights. Not rights that would impair prison security, like rabble-rousing, jumping up on the table in the mess hall and arguing for a prisoner strike and so on, but certainly writing to people outside the prison, where the prison officials can't show that the writings actually impair prison security, ought to be protected. And I conceded that prison security would trump the right of a prisoner to exercise First Amendment rights, but there wasn't any real argument that prison security had been impaired by anything Danny wrote. The panel in the case included two pretty conservative Republicans, Ferdinand Fernandez, still on the court. It's the only picture of him I could find, terrible picture. But he's got a sort of a libertarian streak, a little bit like Alex Kosinski. And he went after the government lawyer. The government lawyer had a tough job to do because he had to show that there was a logical connection between these rules and prison security. And one of the things that Judge Fernandez zeroed in on is that the rule prohibited compensation only for writing for a newspaper, for the news media. And the government said, well, he can write for magazines if he wants to, like The New Yorker. And Judge Fernandez clearly thought that was irrational. I mean, what's the reason in terms of prison security that justifies a restriction on writing for a hometown newspaper, for example, with a tiny circulation, but allowing a prisoner to write for a national magazine that reaches